Well, good morning, everybody. Welcome. My name is Adam White. I'm a senior fellow here at the American Enterprise Institute in our Department of Social, Cultural, and Constitutional Studies. Here at AEI, we spend a lot of time thinking about the Constitution and institutions. AEI scholars have been debating the judicial system throughout the history of this institution. A little over 20 years ago, a scholar who many of you may have heard of, Robert Bork, the former federal judge, while he was here at AEI late in his career, one of the last books he published here at AEI was titled Coercing Virtue, the Worldwide Rule of Judges. It came out in 2003, but it focused especially on the Israeli judicial system, the Israeli court, and the example that it was setting for American judges here in the United States. An example that Judge Bork thought was a very worrisome example of how judges might think about their role in a constitutional democracy. Now, since then, in the last 20 years, debates in America around the courts have shifted along with the shifting of the courts themselves. But meanwhile, in Israel, the debates around the courts have intensified as the stakes around the judicial system and political governance in Israel have only elevated. The debates in Israel have become more prominent, and questions about how the judicial system in Israel reached the point where it is today, how it got there, have only become more prominent, culminating in many ways with the reform debates of just a few years ago. I'm so excited to be joined today by Yonatan Green, my friend, who for the last few years has been working on a comprehensive study of the Israeli constitutional system and its judicial system. And so today we're going to discuss his amazing book. It's titled Rogue Justice, The Rise of Judicial Supremacy in Israel. Yonatan, thank you so much for joining me today.
Thank you so much, Adam.
Thank you. Just a bit of background on my friend. Yonatan Green is an Israeli-American attorney. He was the co-founder and executive director of the Israel Law and Liberty Forum, which, is it fair to say, is an organization that was, at least it was inspired by the Federalist Society here in the United States. More recently, he has been a research fellow at Georgetown Law's Center of the Constitution, which hosted him while he was working on his book. I know he has some big things coming next. That'll be the subject of future discussions, I'm sure. But Yonatan, I'm so glad to be here with you to discuss this book. We're going to cover history. We're going to look ahead to the future. But I thought we'd start in the here and now. So Yonatan, just a very, very broad question. How should we think of the current moment in the history of the Israeli judicial system? I don't mean today or even the last few weeks or year. I mean what strikes me as the latest chapter, maybe the last 10 years. How would you describe the state of the Israeli legal system?
Well, thank you so much. And before I answer your question, I just want to give enormous thanks both to my friend Adam, to the American Enterprise Institute for hosting this talk today, and also to you who have taken precious time out of your day to come and join us for this discussion this morning on a cold Washington, D.C. morning. So thank you to everyone here. First of all, looking at the past 10 years or so, or the past few decades, sort of taking stock of where the Israeli legal system is, and judicial system is, I will pause to look at the here and now, or really at the last year, because one Israeli scholar called it one of Israel's leading constitutional scholars, Yoav Dotan, called it a total constitutional dystopia, especially in light of some very recent rulings. And at the end of my book, I described this as the court's current state as resembling Wile E. Coyote, the cartoon character, when they run off a cliff and is suspended in midair for just a few moments. I think that's, to some extent, where the Israeli Supreme Court is right now, with sort of gravity about to catch up with it. Wow. And we can go into detail about the specifics of here now. But in my book, I really do sort of divide the sort of history and development of this issue into a number of different eras, and we're really now in the era of judicial supremacy. If in the or I should say until the 1980s, and we'll talk about that more, the Israeli Supreme Court took on a much more restrained approach to law. even though it was a sort of robust defender of individual rights and liberties and held government to accountable, it still took its role within the democratic framework very seriously. From the early 1980s and then in the 1990s, we saw a massive expansion of judicial power, very much what Judge Bork was referring to in his book. In the mid-1990s and then later, the court then started its path down the road of supremacy, where it essentially invented an Israeli constitution, a so-called Israeli constitution out of whole cloth. And what we've seen for the past decade or so, and especially the past decade, is this massive acceleration of the court's own judicial supremacy created by its own decisions, where the court has become more and more aggressive in its intervention in government affairs and its willingness to strike down major laws, including laws relating to some of the most contentious issues in Israeli society, including on a more and more flimsy basis when considering sort of the court's legal reasoning and argumentation. And then the last piece of that we're really seeing in the past few years is the court's willingness to even intervene in what might be called constitutional amendments. So even within the framework of the court's own jurisprudence, it has started striking down amendments to the Israeli constitutional order made by the Israeli Knesset. So we are currently in a state, and certainly the last 10 years especially, where we can see quite demonstrably how the Israeli Supreme Court has unfortunately abandoned the law in any familiar sense by any Western standards, and has abandoned democracy in the sense of understanding the judicial role and the court's role within any Western democracy in any republic.
You mentioned you referred generally to a few recent rulings. You've piqued my curiosity. Could you maybe just describe a couple of them? Again, we'll back up into history and move forward, but is there one or two that you'd like to point out in a little bit more detail right away from recent years?
Sure, absolutely. In the book, and I should say this is kind of an important note about the book, in the book I go into sort of almost excruciating detail about a lot of these issues because I believe that the details are so important, and I believe it's difficult to get a real understanding of these issues without looking at the details. So the book, for example, I go over, I think, virtually every single law the court has struck down since it invented the Israeli Constitution in 1995. I should say that since the 2010s, so in 2012 and 2017, this is a major issue in Israel today, the Israeli Supreme Court struck down two separate laws, pieces of primary legislation, which regarded the draft exemption for military service for the ultra-Orthodox community in Israel, for the Haredi community. Now, we can get into this a little bit more later if we'd like to. I am Orthodox Jewish, and I served in the Israeli military. I continue to serve in the reserves. I am deeply troubled by this draft exemption of the ultra-Orthodox community in Israel. But nonetheless, this was a benefit conferred on a minority by the Israeli majority. This didn't, violate any sort of discrimination rules or what have you. And the court nonetheless struck down these historic compromises, very ugly and unseemly and odious compromises, which is the nature of compromises like this, which you sometimes find in democratic society. The court struck down more than once this critical compromise in Israeli society based on the flimsiest of legal grounds, which we can get into. And this has profoundly destabilized the Israeli political order, profoundly destabilized many other sort of related socio-political issues in Israel. And I'll give one more, quick example, is that, and this is really sort of very, very quickly and in a nutshell, but in 1995, the Israeli Supreme Court decided that Israel has a constitution. And despite this having always been a fairly preposterous claim, and a fairly ludicrous claim, as I think demonstrate very well in the book, it at least had some coherent framework to it. And the court basically maintained that the Israeli Knesset, the Israeli legislature, could function as a constitutional assembly and could at will create norms of a constitutional nature. And this was the sort of basic idea, the basic premise of what the court was doing. And then since 2017, and you asked about specific rulings, since 2017, the court has increasingly sort of developed its jurisprudence to say, well, yes, the Knesset acts, the Israeli legislature, the Knesset acts as a constitutional assembly that can make constitutional rules, but we're actually going to exercise judicial review over that as well. And we're going to tell the Knesset, as the Constitutional Assembly, right? Imagine the Constitutional Assembly in the Constitutional Convention in Philadelphia, and someone standing over its shoulder and saying, "Oh, you know, Article 5, you can't write that. That won't work." Write some judicial organ doing that. And then this culminated very recently in the 2024 decision in the unreasonableness case, where the Israeli Supreme Court struck down a constitutional amendment by its own jurisprudence, struck down an amendment to the Basic Law, which would have curtailed some of the court's powers. So this is a major development and very recently.
All right, we're going to get back to the reasonableness or unreasonable test in a little while. But now let's go back in history a little bit to the start. I was going to ask you about the Israeli Constitution, and as you pointed out, that's a complicated question. How would you describe, especially to an American audience, what the Israeli Constitution is and isn't?
Absolutely. So I should say that I dedicate almost half the book, I should say the second half of the book is really dedicated to the constitutional questions. But there's a reason why so much of the book beforehand is not dedicated to the constitutional issues. And you sort of make the point that while the constitutional issues are important and they demand a lot of attention, they get a lot of attention, we shouldn't lose sight that there are profound problems and deeply troubling doctrines, et cetera, that the court has developed, which have nothing to do with the constitutional questions. And even if all the constitutional questions were to be resolved, or if what I'm about to describe had never happened, we would still be left with these very severe problems and sort of grievous flaws that need to be addressed. But going to the constitutional issues, the sort of short history of this is that Israel was a country without a constitution. And to this day, Israel has nothing approaching a constitution. There is no single document, there's no single instrument which would be considered a constitution in the conventional sense, with a beginning and end, and which was enacted for that purpose, which is a product of that kind of constitutional deliberation by an organ which was elected for that purpose, that was ratified in some kind of referendum, et cetera, et cetera. None of these elements appear or exist for anything remotely resembling a constitution. And Israel consciously declined to enact a constitution when it was founded in 1948, and I go into some of the history of that. So until the 1990s, Israel was a jurisdiction of parliamentary supremacy. Now, this doesn't mean that there were no checks and balances on majoritarian power or on governmental power, and we can go into that a little bit. It's both the sort of electoral system in Israel, the coalition parliamentary system. In Israel, no single party has ever won an outright majority in the Israeli parliament. So all legislative actions and all government is essentially dependent on building coalitions between these sort of disparate political parties with different agendas pulling different ways. The Israeli Knesset is very small, and the governing majorities are typically rather small. So you have a small group of backbenchers can almost always derail the government, collapse the executive government. And one can go into this with some detail. An important other element of this is that throughout that time, with Israel as a system of parliamentary supremacy, the Israeli Supreme Court took on an extremely robust role in holding government accountable and in making sure that executive government especially acted within the constraints of the law, protecting individual rights and liberties, sometimes to what might consider a highly activist extent, sometimes inventing rights and liberties which are typical of a democracy, even though they weren't sort of anchored in any statutory way. And I think that was sort of admirable in many ways. But to keep my answer shorter than it otherwise could be, so Israel was a system of parliamentary supremacy and still today has nothing approaching a constitution. But in 1995, the Israeli Supreme Court decided to retroactively recognize a bunch of laws. Some of them passed in 1992. It then expanded this recognition to a whole subset of Israeli law, and decided to elevate a bunch of laws to semi-constitutional status.
These are the basic laws?
And these are some of the basic laws.
Okay.
And basic laws were, and I should say a word about basic laws, even though I sometimes try to avoid it because I feel like sometimes it muddies the water, or in Hebrew we say, for so many trees you can't see the forest. But basic laws were very simply...
We say that in English too, just...
Okay, I'm never sure. This is my problem, but being with my sort of bilingual background.
I didn't mean to interrupt.
No, of course. You're never sure when an idiom is cross-cultural. So very briefly, a word about basic laws, because this is a term that comes up so often in this context.
Yeah.
When the Israeli government in 1949 or 1950 declined to enact a constitution, they said, well, we will enact a certain form of law called basic laws. These are completely ordinary laws with no special standing or status, enacted the exact same way that any other law is, annulled the same way, amended the same way. These are just 100% ordinary laws. They were regarded as ordinary laws by the entirety of the Israeli political establishment, the electorate, and of course the legal establishment, including the Supreme Court. Everybody agreed on this. All these basic laws is that they signified or they served as a draft chapters of a future constitution. So if you will, the Knesset would enact a basic law, let's say basic law of the Knesset or basic law of the judiciary, and these address some institutional rights, some core institutional aspects of Israeli government. They were completely ordinary laws, but the idea is that these were touted as potential chapters, potential components of a future constitution when such constitution were to be enacted in the future. And this was the consensus. More specifically, in 1992, the Knesset enacted two important basic laws called Human Dignity and Liberty and Freedom of Occupation, and these were a Bill of Rights of sorts. And when these two laws were enacted, we should note, if you're thinking about the sort of so-called constitutional status of these two laws were enacted at 4 a.m. in a twilight Knesset, meaning the Knesset had already disbanded and called for new elections. The government had already collapsed. These two laws were enacted, and sort of the main one of them was enacted by a majority of 32 to 21 legislators. Less than half the legislature participated in the vote. Less than half the legislature were in the building. Wow. This was universally not regarded an important part of Israel's sort of constitutional history. It was not reported anywhere in the media in the following days. These were simply not a moment of constitutional or great legal consequence. And finally, I should say, again, this all sort of leads up to this, to refuting this argument that these have any sort of constitutional standing. The sponsors of these laws, of these two laws in 1992, explicitly said on the Knesset podium, before the Knesset, during deliberations, these are not a constitution. We are not empowering the court with the authority of judicial review. We are not setting up a constitutional court with the power to strike down laws, et cetera, and things to that effect. So the court comes along in 1995 and says, actually, we're going to regard these two new basic laws as the Israeli Constitution. We are going to regard the entirety of Israeli basic laws to some extent as the Israeli Constitution. And since then, the court has proceeded to strike down dozens of laws, dozens of pieces of primary legislation.
Yeah, I want to ask a little bit more about the origins of this, but let's just pause for a moment. Can you just give folks a sense of what the Israeli Supreme Court actually is? How many justices are there? How do they do their work? And how are they appointed to the court? Just briefly, and then I want to kind of get back to this history. But we keep talking about the court without actually explaining what the court is.
Absolutely, and I not only do I agree with you, but the first section of my book, which I called the Foundation, are two chapters that deal exactly with these questions, with the sort of structural features of judicial supremacy in Israel. So the Israeli Supreme Court is the sort of apex court in Israel. It's a common law system, so it's similar to the U.S. and today the UK and Canada and Australia in the sense that you have sort of this hierarchy of courts. It's not a constitutional court in the sort of European sense. The Israeli Supreme Court has two primary functions. One is as an appellate court, where it hears appeals to civil and administrative and criminal cases. And this is already interesting because it hears appeals as of right to almost any consequential or major case at the district court level. So district courts have original jurisdiction, which the district courts are the appellate intermediate tier courts in Israel. So the lower magistrate courts and the district courts. So the district courts have original jurisdiction for a host of issues, really all issues of consequence. And then as of right, the next level of appeal is the Supreme Court. So even looking at its appellate jurisdiction, the court has this incredible authority, and it hears upwards of 10,000 cases a year. 10,000 cases a year. About half of those are through its appellate function. The court's second function is as what's called the High Court of Justice, or what Israelis call Bagatz, which is an acronym of the High Court of Justice. And as High Court of Justice, and this is rather remarkable and worth really thinking about for a moment, as High Court of Justice, the Israeli Supreme Court has first and last jurisdiction. It has original jurisdiction over almost virtually any consequential challenge to government action, be it executive or legislative. So virtually any petition against government action will originate in the Israeli Supreme Court as High Court of Justice, and there it will end. Yeah. There's no further appeal. There's some minor proceeding, which is called a rehearing, which is discretionary. The court can decide whether it wants to do it or not. So even in this sense alone, the Israeli judiciary is sort of deprived of that process of what we call in the U.S. percolation, where cases mature and ripen as they sort of wind through the different tiers of the legal system and of the judiciary. Here it shows up in the Supreme Court. Sometimes an issue can be decided within days, sometimes years. But a judicial decision is made, and that's that, and that is the end of it. Yeah.
And also just say, am I right? And just unlike the U.S., where we still have somewhat tight laws in the federal courts about who has standing to sue, that's been relaxed. So the reason why there's so much litigation, and one of the reasons why the Supreme Court decides so many consequential issues, is just about anybody could well, I was going to say just about anybody could bring a suit, but maybe a better way to put it is just about any issue of consequence will be brought as a suit in court. But I cut you off. I think you're about to talk about how the justices get on the court.
Exactly. I'll say something about judicial selection, and then I do want to go back to your comment on sort of standing and justiciability. Sure. So just in terms of the way that judges are appointed, both in general in the Israeli judiciary and to the Supreme Court, the short version is, or in a nutshell, the Israeli Supreme Court justices decide who their colleagues and successors will be. And it is not accidental that the phrase or that the term oligarchy is often employed in this context by leading Israeli jurists, including former Chief Justice Moshe Landau, including by Stephen Calabrese, Professor Stephen Calabrese, who he called the Israeli Supreme Court for this reason a self-perpetuating oligarchy. And the details of that, very briefly, is that judges in Israel are appointed by a 9-member committee. This is defined by statute. This has been in place since 1952. Only a minority of those committee members are elected representatives. 2 are members of Knesset or legislators. 2 are members of the executive or cabinet ministers. The other 5, so a majority on that committee, represent the Israeli legal establishment. 2 are represent the legal profession, the bar association, the National Bar Association, and 3 are serving Supreme Court justices. Those Supreme Court justices always vote as a block. They've never voted separately. They always vote together. Even though they're supposed to exercise independent judgment, et cetera, they've never voted separately. Critically, to appoint a justice to the Supreme Court, you need a majority of 7. Now, if you're doing the math, that means that the Supreme Court justices on this committee wield an effective veto on any candidate to the Supreme Court, and they can thus really define and decide what the shape is of who joins the court. Now, this is not only one could raise principled or theoretical objections to such a system. Of course, there are also just justifications for such a system. Yeah. But perhaps more importantly, this mechanism or this veto power has been used, and I should say abused, over the years, in fact, in order as the court has blocked perfectly and eminently capable candidates who were sort of universally agreed to possess the qualifications to be Supreme Court justices, and who were desired by the electorate and by the elected branches. And they were blocked by the Supreme Court simply because they didn't like their jurisprudence. They didn't like their judicial worldview, and they were not considered sufficiently activist for the court. So they didn't share the court's supremacist worldview. As Justice Aharon Barak put it regarding Ruth Gavizon, one of the people that the court blocked, she wasn't one of the family. And I don't know if he was invoking the Godfather and Don Corleone or something else. I don't know if Justice Barak realized how mafia-esque quite that sounded, and he later said she had an agenda. So this is, I think, a critical component of judicial supremacy in Israel.
We'll get back to standing. We'll talk about standing when we talk about the growth of the court's powers. But on history, a couple of times in talking about the absence of a formal U.S.-style constitution, you've said Israel chose not to make that. But as your book points out and explains, it's not as though the first Israeli Knesset woke up and said, oh, no, we don't feel like doing this today. I mean, this is a decision that's really been shaped by history. And so what I'm asking is, in the origins of all of this, how much of it is a reflection of the fact that Israel was immediately fighting wars, but also how much of this did they inherit from the British Mandate? Since a lot of the Israeli system of governance was handed down, at least in part, from the Mandate. How would you allocate sort of the origins of these problems?
That's a wonderful question because I think it's such a good opportunity to explicate this issue because I think there are misconceptions about the way that came about. And I think a common sort of misconception is, well, Israel was at war with seven invading Arab armies, and they had sort of this, survival to prevent their own extinction, and this is why Israel did not enact a constitution. And that's frankly not true at all, meaning that, of course, to some extent, being in a war of survival was an element in ultimately that contributed to the fact that Israel did not enact a constitution. However, I explain in the book there are many other factors that contributed to this. One significant one was, of course, Israel's background and influence by the common law system and by the British Mandate. So a great deal of the Israeli legal system and sort of system of government has been inspired by or influenced by, of course, the common law tradition and specifically sort of the English system of government. Even if it's not a direct effect, meaning even if we don't look at it as a sort of direct connection between the English system and the Israeli system, it is certainly true that Israeli jurists and Israeli politicians and Israeli, the people that were thinking about this, the idea of not having a constitution was not so outlandish. Meaning if you're coming from a British legal and political tradition, then as I'm sure many of you know, the United Kingdom does not have a written constitution or a conventional constitution. Some might say that they have an unwritten constitution, but that's sort of a more sort of diffuse and vague idea. They certainly have no written constitution. There are no sort of formal checks on majoritarian parliamentary power in the UK. You have this very famous passage, which I quote in the book from, I think from Sir Coke, that no power on earth can undo what Parliament hath done, and there is no power that Parliament doesn't have, et cetera. Right. So it wasn't so strange for Israelis to consider this a legitimate course of action, to just not have a constitution. As I should say today, the United Kingdom to this day does not have a written constitution, neither does New Zealand, for example, both famous authoritarian despotic dictatorships, as we know. So that's one element. I do, however, want to emphasize another part of this, which I go into some detail in the book. I'm a constitutionalist, and I am generally in favor of written constitutions. I think it's the sort of, the correct default model for democratic countries, including counter-majoritarian mechanisms, including even judicial review of primary legislation. I think, the way that the United States is shown in this way is a correct way, and this is really the way to go. However, there are exceptions, and there's a good argument to be had that Israel was certainly an exception to that rule in 1948 and in its founding, and perhaps even today is an exception. And one of the points that I make is that Israel was unusual in the way that it didn't have a permanent historical population when it was founded. So most new countries, most new democracies have a certain group, a certain demographic core sharing very, very similar, not just values, but being, fundamentally similar in a lot of ways, who have been there for a long time, for perhaps hundreds, perhaps even thousands of years. And the vast majority of the Israeli population were, in 1948, were immigrants from all over the world who had come very differently, who had come very recently, with profoundly different ideas of the world, profoundly different cultures, sometimes even different languages, different modes of behavior, different conceptions of government, and profound disagreements on everything, on almost every issue imaginable. And there was a genuine risk, and I think people sort of underestimate and underappreciate this. There was a genuine risk at the early stages of the Zionist project of balkanization, of a genuine fractioning of the Zionist project in the early state of Israel. And in this sense, not adopting a constitution was a prudent measure, and it quite possibly saved the early Israeli state, because not just a constitution and the rigidity of a constitution, but even the process of trying to put together a constitution may well have been too much strain, or more strain than the Israeli political order and societal order could have handled at that time.
Yeah.
And what it quite possibly required then, and perhaps even requires now, is that flexibility, that agility to sort of bend and amend itself and change itself and reinvent itself as the Israeli society sort of coalesces and crystallizes and becomes something which is a little bit more homogenous and coherent.
I mean, that's fascinating, and it sort of spurs a question with me then. You know, here at AEI, we're spending a lot of time celebrating America's 250th, the 250th anniversary of 1776. And it's in the conversations we've been having around it, the events we've been having around it, it's a stark reminder that we didn't start with the Constitution either, right? Before that was a dozen years under the Articles of Confederation during the war and immediately after the war. But even before that, we had a century of different colonies coming about in different ways, under different charters, basically the same legal systems, but carried out in very different ways. It did take, a century to knit the country together to a point where, in the opening lines of the Declaration of Independence, the authors would say, "We are a people, separate from the English people." So it took us, a century, and so I understand that is actually fascinating. I hadn't thought about that. The point that at the outset for Israel, there was a real risk of balkanization. You could not have written a U.S. Constitution in 1700. You had to wait a century. Not to skip too ahead, I want to keep talking more about history, but since we're on the point about balkanization, do you think there has come a point or could come a point where the constitutional question is more plausible, or is it just because of the way history has played out, Israel just didn't get to that point?
I think to answer briefly, one of the arguments I make in the book is that if there is a point, or if there was a point where Israel could come closer to enacting a constitution, or to agreeing on some core principles, both of government and of other sort of substantive issues, which would serve as a basis for a constitution, that point has been severely and perhaps indefinitely postponed or pushed away by the Supreme Court itself. And what the Supreme Court has done to a great extent in Israel, by its aggressive push for judicial supremacy, by its invention of an Israeli constitution, by its aggressive judicial review of legislation without any constitutional basis, that has caused irreparable harm, or at least in the near term irreparable harm, to the very notion of Israeli constitutionalism. And many Israelis, and this is when you think about it, this is a profound backfiring of the constitutional project, because even in its most charitable view, right? If we're going to describe what the court did in the most generous terms, we can say that the court was trying to advance a constitutional project in Israel and to bring into being a constitutional culture in Israel. And this is, I think, one of the most charitable and positive ways that you can sort of frame what the court has done. And that has backfired spectacularly, because what it has caused to happen is that the Israeli public have entirely lost faith in the idea of constitutionalism, in the idea of impartial judicial review, which isn't about policymaking and values. It's about upholding the law and protecting individual liberties and rights, et cetera, and holding government accountable. There's a very famous quote in which Aryeh Deri, is a veteran Israeli politician, and famously in the late 1990s, after the court's constitutional revolution, this is an ultra-Orthodox man, a man of who represents a large demographic, which is sort of a sectorial, faith-based party, so sort of strictly religious. And he said, if there were a bill to enact the Ten Commandments as a basic law, the biblical Ten Commandments, he would vote against it, because he was so suspicious, completely justifiably so, of what the court would do with that kind of bill. So in many ways, maybe we were drawing closer at certain stages to that happening, and I should say there's an example of that. But the court has completely undermined the notion of an Israeli constitution. And I think the last point I'll make about this is that one of the critical factors which is required for that kind of constitutional making, right? For the coming together and building some kind of consensus, including some very ugly and undesirable compromises, like we had in the Philadelphia Convention, where kind of there was a lot of horse trading and negotiating, and eventually we put something together which each faction got something of what it wanted and lost something of what it wanted, et cetera. You need to have a sort of mutual and sort of universal incentive on the side of all parties to get to that point and to make those compromises. Yeah. And under the system of judicial supremacy currently existing in Israel, a major part of Israeli society has no such incentive. Because if you're getting everything you want through judicial fiat, if you're getting everything you want by the court just imposing its will on society, imposing your own agenda on society, then why negotiate? Why compromise? Why even engage? Why even persuade the public and win elections if you can simply get your way through the court? So in this sense, the court has, meaning even if we're talking about the noble desire of Israelis getting together and getting into a room and hammering out, some really important compromises about their system of government and even enacting a constitution, the court has undermined the possibility of that happening. And this is one of the reasons why it's so necessary to roll back some of the court's power as a precondition to properly considering these questions in Israeli society.
Okay, well, before we get back to the question about rolling back the court's power, let's talk about how the court rolled ahead. And this is the part 2 of your book. It's called Ascendancy. And you go doctrine through doctrine. You mentioned dairy a moment ago, and in your book you cover the dairy doctrine. I want to walk through just a few of these. We've alluded to some of them, but I wanted to get into them in a little bit greater detail.
So, yeah, absolutely.
Is there one you want to start with? I've got a list, but if there's one
no,
you're
please, go ahead.
I'm kind of curious if you're chomping at the bit. But let's just start with the reasonable test, since we already started with that a little bit. How did that? You've touched on it a little bit, but could you say a little bit more about what it actually means in practice? How has the court developed this reasonable test and used it against other parts of government?
Absolutely. So, as I'm sure most of you know, in most legal systems, you have judicial review of administrative action or of executive action, right? Courts hold government accountable to make sure the government acts within its legal authority, to make sure the government is doing what it's supposed to do, or that government is doing what it is allowed to do, what it can do with its permission under the law. This is the classical view of judicial review of administrative action, et cetera. The Israeli Supreme Court, starting in the early 1980s, but in a way that really accelerated in the late 80s and early 90s, invented a doctrine called the unreasonableness standard, or we can just call reasonableness. The unreasonableness standard for review of executive action. And despite its namesake, right, the UK has a doctrine called unreasonableness, called Wednesbury unreasonableness, and this has been to some extent adopted.
Called what?
Wednesbury.
Wednesbury.
It's spelled with a D in there, like Wednesday, but it's Wednesbury reasonableness. And this is the UK original sort of common law doctrine. It postdates the US, so it's not sort of ingrained in US common law because this is from the 1960s and 1970s in the UK. And that was a slight deviation from the classical view or the traditional view of that kind of judicial review, because it said even sometimes executive action can be within the formal legal authority, but it can be so outrageous, so insane, that no reasonable authority could possibly have adopted it, and therefore it's illegal. And the idea is not that therefore it's illegal, but that therefore it exceeds the mandate of legal authority given to it by statute. So it still rests on this idea that statute has granted certain authority to the executive, and there are some instances in which the executive can act in a way which, while it meets the letter of that law, it clearly violates its spirit, it clearly violates the original grant of authority given by statute. And this is sort of a critical distinction. And the classical example is, right, the statute says the king can appoint, or prime minister can appoint any person as a cabinet, or anyone as a cabinet minister, and the king appoints a horse. His horse as the Minister of Finance. And we can say, well, nothing in the law says that he can't appoint his horse, but we understand that this is patently outrageous. Okay. Pretending, borrowing the term unreasonableness, pretending to base its jurisprudence on this idea of British unreasonableness.
Yeah.
The court then developed a doctrine that it called unreasonableness. And this was the court asking, did the government reach the correct outcome? Did the government correctly weigh the competing factors and consideration when making its decisions? Yeah. And I think most of us can already tell this is a ludicrous idea of courts reviewing the legality of government action. Yeah. Because this is the very essence of governing. This is what governing is. This is what governments do. They, within their legal authority, within the grant of authority given by statute, and we're not talking about a non-delegation doctrine, we're not talking about anything else. So within the formal, proper authority granted by statute, government can then weigh a host of considerations like resource allocation and prioritization and value-based decisions and ideological decisions and preferences of society, et cetera, and then come up with a certain policy or make certain decisions. And what the Israeli Supreme Court has decided is that it can evaluate any conceivable government decision, any government policy. Imagine like a tax rate, right? And down to the down to the numbers,
down to the decimal point,
down to the decimal point,
yeah.
or where the government builds bomb shelters, or does a local council build a ritual bath for ritual cleaning under Jewish law, and of course, and this is really important to clarify. All these questions are never a question of legal authority, right? Of traditional or conventional legal authority. Because if they were, we wouldn't be talking about reasonableness. Meaning, if there was a question of, okay, this is something that clearly statute mandates that the government acts a certain way or prohibits a certain type of action, then we're no longer in the territory of reasonableness. Yeah. To begin with, we're only talking about reasonableness when there is no clear statutory mandate or prohibition. And I'll sort of finish that note on reasonableness. And this has been devastating for the Israeli legal system. There are many other reasons why I get into this in the book. It's sort of, I say that reasonableness is sort of a malaise that infects the entire legal system because it reflects such an abandonment of law itself. It's not just a question of legal interpretation, of taking a statutory text and interpreting it in a sort of outlandish or crazy or ludicrous way. It is quite literally saying, we as judges will intervene in government action without any regard, without any nexus, without any attempt to base this decision-making on any sort of recognizable legal grounds. And the last thing I'll say about this is that a critical component of that, or one of the biggest examples of this, is intervention in appointments. Yeah. In executive appointments throughout the board. I was going to ask about that, yeah. So if you can think of chief of general staff or chief of national police or head of any large important agency, right? The most senior executive appointments in executive government, right? Some people say that the essence of executive government is to hire and to fire. Like you can formulate any policy you want, or you can write any law and make any regulation, but at the end of the day, if you can't hire or fire the key people implementing these policies or the key people exercising government authority, then your governing power is virtually non-existent or extremely limited, right? And there's someone else, I think maybe someone in the Reagan administration put it as sort of that policy is personnel or something like that.
Yeah, personnel is policy.
Personnel is policy.
Yep.
So the Israeli Supreme Court, under this idea of reasonableness, proceeded to intervene in executive appointments across the board. And again, this is without any sort of statutory basis. This isn't because someone wasn't 35 years old or because someone, not enough time had elapsed in some other high-ranking position or whatever it is. This is purely on the grounds of judicial decision-making and intervention. And this goes all the way up to cabinet ministers. So you can imagine the president appoints the Secretary of the Treasury or the Secretary of War or whatever it is. Sure. And the Supreme Court comes along and says, well, we think that's unreasonable. Why is it unreasonable? Well, maybe it should be someone from a different demographic. Yeah. Maybe you haven't sufficiently taken that into account. Or maybe, and again, this is with no statutory basis, or maybe they had some inartful tweets from a few years ago, which we think, render them an inappropriate candidate. So, and this is what the court has effectively done. Again, these are not hypothetical situations. The court has consistently, methodically, relentlessly, over the past 20 years, intervened in executive appointments at the highest level, from cabinet minister down to chief of general staff, chief of police, major agency heads, and throughout the entire Israeli system of government.
So one thing that really interests me about the debate, about the way that the reasonableness standard is played out, is that there's all parts of American law that turn on reasonableness standards. Right in the Constitution, in the Fourth Amendment, there's the protection against unreasonable search and seizure. My specialty for my sins is administrative law, and lots of administrative law in the Administrative Procedure Act is about judges deciding whether an executive action was arbitrary and capricious. We have, in constitutional law, the courts can ask whether there's a rational basis for an act of Congress, which is an extremely low bar. In American law, when you ask, is there a rational basis, it really does mean, would it have been impossible for Congress to have formulated a coherent explanation for this policy? Things virtually never get struck down on that basis. So the legal system has used this, and I'm sure a lot of cases have gotten things wrong. Why do you suppose that reasonableness, which as you point out, really was invented by the courts, why do you suppose it went off the rails so badly in the Israeli legal system?
Well, thank you. I should say that, first of all, I appreciate meaning the very recognition that it went off the rails, or that it is distinct and separate from arbitrary and capricious or other similar standards. And of course, any legal system and any jurisprudence is replete with all these kinds of somewhat or slightly vague standards and notions. However, rational scrutiny, rational basis scrutiny, arbitrary and capricious, these have distinct meanings, right, within the legal concept. They have a distinct idea. And importantly, they are an illusion, and at least they try, and they can involve a good faith attempt at some kind of objective test. Unreasonableness, for example, is sort of asking, what would the average person think of this? Is this something that virtually any police officer would agree makes sense, or virtually any person would agree this is a reasonable basis for your suspicion, justifying a search or a seizure or something like that. And arbitrary and capricious have specifically defined meaning, right? Arbitrary could be flipping a coin or rolling a dice, or or doing a eeny, meeny, miny, mo, right? That's arbitrary. So first of all, I should say that by the Supreme Court's own jurisprudence and own explanations, reasonableness is separate and a whole different idea from arbitrary and capricious. And the court does me the service of not even trying to pretend that this is similar or the same. Why it went off the rails so far? I think I say that in the book I really don't go into the why very much, and my book is very much about the what and the how, and not so much about the why. And it's always a tricky question. And I say in the book I'm doing the analysis and not the psychoanalysis. But the why is very strict. I mean, to some extent, the why can be divided into two, but this is more largely the why of the entire project of Israeli judicial supremacy, which is A, the desire to intervene in policies you don't like. And the court saw again and again policies that it found objectionable or undesirable, and maybe justifiably so. Maybe the court really had a point when it thought that certain people were unfit for public office just because they were, but with no legal basis. Or maybe they really thought that a certain policy was odious, right? And when the government in Israel in 2006, the executive government was deciding where to place bomb shelters around Gaza and where not. Again, fully within its legal authority, and there were questions of resource allocation, there were geostrategic questions, et cetera. I won't get into it. And maybe the court thought that this was a profoundly misguided idea. So one is just the inability to resist the temptation to intervene with things you don't like. That's the first sort of engine or drive behind reasonableness. And the second,
like the absolute power corrupts absolutely factor.
And even to an extent, and this is to maybe improve upon Lord Acton's insight here, also the temptation of absolute power corrupts, right? Meaning even the ability, absolute power within reach corrupts, absolutely. So that's A, and then the second component of that is, of course, the desire for judicial supremacy itself, meaning the goal in and of itself of accruing more and more judicial power, I think, was a driver for the court's development of these ideas. And there are other questions of, the instability and unsophistication or lack of sophistication of Israel's political branches, the way in which sort of the legal establishment and legal academia and other parts of the legal system were sort of complicit in this, and were sort of very willing to not push back against the court on this. So all this enabled the court to do so. And this, I don't know if one of your, somewhere on your list was sort of standing and justiciability.
Yeah, I was going to get to that when we jump in.
Yeah, okay, so just very briefly, I mean, the question of standing and justiciability has been such an important contributor to this as well. And I think they sort of form this troika. They form this, right? I say in the book that the combination of justiciability, the court's doctrine of justiciability, and reasonableness create this black hole, this vortex, from which no particle of government action can escape. And what happened was that again in the 1980s, under Justice Aharon Barak, who I haven't mentioned until now, the Israeli Supreme Court from the 1980s had completely abolished the entirety of Israeli jurisprudence on standing and justiciability. So if standing means, right, not anyone can just demand some remedy of the court, but rather it has to be someone with a distinct grievance, someone with a particularized individual dispute with the government. And we're, of course, on the federal level, we're familiar with the sort of cases and controversies idea. And justiciability means that certain disputes or certain issues are outside the purview of the court, or simply none of the court's business, whether it's for reasons of prudence, whether it's for reasons, just to say that there's no legal basis, there's no legal sort of argument here for intervention. What the court did in the 1980s very simply is say, there is no such thing as either of these. Yeah. There is conceptually, there is no issue outside the court's authority. There is no issue which can be said to be not part of the court's purview or jurisdiction, even though there's no sort of formal legal angle or argument on this, even though it's clearly a matter of policy for the elected branches of government, et cetera. And in terms of standing, the court said, we will entertain petitions from anyone who objects on principled grounds to what the government has done. And you were saying it well earlier. You were sort of debating whether is it anyone or anything, or right. So the real thing is, and this is not just many Israeli scholars have put it this way. After what the court did, after abolishing the threshold requirements and after developing the reasonableness review, we came to a situation in which anyone could challenge any government action on any grounds. And this is the reality of the Israeli legal system and Israeli judicial review of executive action.
Years ago, there was a judge across town in the D.C. Circuit. He's chief judge of the D.C. Circuit, which hears a lot of cases involving regulatory issues. And his name was Abner Mikveh. And there used to be sort of a saying that there's a doctrine of mikveh standing, which is if you filed a case, then Judge Mikveh will find that you have standing. That it was basically wide open. But the courts, both the Supreme Court and the D.C. Circuit, pushed back against that a lot in the 80s, 90s, and beyond. And here Justice Scalia really is important because as he wrote about standing, I was lucky, astonishingly, to take a class from him about standing a little over 20 years ago. He always framed it as standing in the separation of powers. He wrote that standing is an essential element of the separation of powers. First of all, to keep the courts from micromanaging Congress, but second, and this gets back to a point you raised earlier, to create a separation between the work of courts and the work of executives. The work of an executive is full of prudential judgments, right? Most laws, even when the laws are written very clearly, there are real questions about where you draw lines about enforcement. And it's a good thing, or else I'd have more speeding tickets, right? That's the classic example. Speed limit is 55, but maybe you can go with 57, maybe even 61. You can't possibly you can't stop every speeder, so you have to make judgment calls. And more seriously, presidents and administrations have to deal with enormously complicated questions about resource allocation, really fundamentally non-legal prudential questions about should we do something here or 10 feet over here. And so standing doctrine was really reasserted by the courts in the US in the 80s and 90s to make sure that the courts were in the business of principled legal judgments after the fact, sort of looking back at what's happened, versus the executive branch, which is making, to be sure, legal judgments, but also a lot of prudential judgments in the here and now. That's a place where the way you described it really dovetails well with recent American experience. Can I ask you about one more thing? And I have to admit, when I first came across this, I thought it was a typo. This is objective purposive purposive.
Purposive.
Objective, purposive interpretation. I can't even say it. What is it?
Objective purposive interpretation.
It really rolls off the tongue when
it
you
rolls
say
off
it.
the tongue. It's practice. It's
Here,
practice.
this is like here at AEI, we perfected the word semi-quincentennial.
Right, exactly.
Yeah.
I can't say that. But in Hebrew, I think it's even worse. It's parshanut tachlitit objektivit, which also is kind of a tongue twister. And luckily, in the book, I just abbreviated it as OPI.
OPI, yeah, okay. What is
This
OPI?
is worth saying a word about because this is almost was sort of the basis of the first revolution or the first part of the revolution that the court brought about in Israeli jurisprudence and in the Israeli political system. And actually, your question about OPI, which I'll get into in a moment, dovetails really well with your comments on standing because all of these issues are not really technicalities. And the question of who can demand remedy from the court, right? Who has standing before the court, that's not a technical, legalistic, formalistic issue. It's an issue that goes to the core of how we perceive the judicial function and how we perceive the court's role in government and in society. And similarly, the question of statutory interpretation and how the courts apply laws is not just a question of academic debate over exegesis and interpretive methodology, et cetera. This goes to the core of the understanding of the court's role. And one methodology might say the court's role is to apply the law as it is. And another type of methodology might say the court's role is to be an agent of justice and morality and virtue in society. So these are not just technical questions of how do we interpret laws, they are fundamental ideas of what the court's role is. So very briefly, in the late 1980s, Justice Aharon Barak and the Israeli Supreme Court pioneered a system called objective purposive interpretation. And I like to say, Voltaire famously said that the Holy Roman Empire was neither holy nor Roman nor much of an empire. So similarly, objective purposive interpretation is neither objective nor purposive nor very much interpretation. What the court decided, and this is the core of this interpretive method, is that laws should be applied according to what their purpose ought to be, according to what their purpose should be in the judge's estimation, not according to their text, not according to the purpose that arises from the text, not according to the purpose that maybe is explicitly stated in the text, not according to the purpose which was desired by the legislature or the legislators or the public or the bill, et cetera, none of that. This method says laws should be applied according to the purpose that the judge thinks is the proper and correct purpose for this law. And this is at the highest level of abstraction. And Justice Barak has a wonderful list. He has like a little grocery list, which he clarifies is non-exhaustive, of all the things which could affect your purposive interpretation. And it's like justice and values and morality and truth and everything that's good and wonderful in the world. At the end of that chapter, my chapter on objective purposive interpretation, I bring some of these famous, this famous saying from Justice Cardozo, where he says a judge is not a knight errant pursuing his own vision of beauty and justice, right? And this is exactly how the Israeli Supreme Court envisions the role of the judge and the role of the court. I don't know if you can see that quote in there. So objective purposive interpretation served really as the basis of so much of what the court did later, because the court could say the objective purpose of this law, even if this law says nothing about your authority to appoint a cabinet minister, right? Even if the law just says you can appoint a cabinet minister and there's no specific limitations on that, we can say, well, the objective interpretation of this law mandates that you don't appoint anyone who's publicly controversial, or you don't appoint someone that the court thinks is insufficiently capable or whatever it is. And this is just one example of many. So this served as really the foundation of so much of what the court did. And critically, and this is really important, everything I've described so far is good law, meaning it is still fully enforced and in power. Objective purpose and interpretation is the primary, really the exclusive mode of interpretation today on the Israeli Supreme Court and throughout the Israeli legal system. These are not archaic ideas that have sort of fell out of fashion, to some extent, not living constitutionalism to some extent. This is still the foundation and basis of all Israeli jurisprudence today.
Yeah, and the full quote, it is really great, from 1921, this is Justice Benjamin Cardozo. He says,
Who's a distant relative, I should say, of my own.
get out, really?
Yeah.
I am actually related to Justice Byron White. No, not really. But that would be awesome. He was amazing. The judge, even when he is free, is still not wholly free. He's not to innovate at pleasure. He is not a knight errant, roaming at will in pursuit of his own ideal of beauty and goodness. He is not to yield to spasmodic sentiment, to vague and unregulated benevolence. That's a great line.
If you pass me that,
Yeah, of course.
While you ask me your next question,
Sure.
I'll try and find my quote from Barak for his grocery list of ideas, just because you can contrast that with this idea of the knight errant who sort of goes on his quest for justice. But
while he's looking for the quote, a couple things I meant to say up front. We are going to open the floor to audience questions in just a moment. And by the way, we can only begin to sort of just glide across the depth of detail in this book. We do have free copies for people to take. Please do take a copy. If they run out, please buy a copy. And if you do take a copy for free, please buy a copy for a friend who ought to read it too.
And I should say, as you take a copy, I will also immediately, when we're done, sit down there and happily sign any copies for anyone interested. I would just to finish this thought, here's the list, and just have in mind of what Justice Cardozo said about the knight errant, right, yielding to spasmodic sentiments of right, etc. Yeah. Here's Barak's answer to right, what is a potential authentic, right, so-called objective purpose of the law, not subjective, right? Subjective is just what the legislators thought the purpose was. Here's what Barak thinks are the legitimate objective purposes of the law. Here we go. One needs to take a deep breath. Equality, justice, morality, social objectives of the separation of powers, the rule of law, freedom of expression, freedom of procession, of worship, of occupation, human dignity, judicial integrity, public peace and security, the democratic values of the state and its very existence, good faith, natural justice, fairness, and reasonableness. And like I said, the Justice Barak clarifies that this is a non-exhaustive list, that it's really anything there is. So I think this is one reason, I should say, on that context of interpretation, Judge Richard Posner, who was another really important critic of the Israeli Supreme Court, among other things, and himself not exactly a conservative judge, meaning he adopted a view called pragmatism, which many consider, sort of an activist view of judging.
He was not exactly a textualist.
He was not a textualist, and I don't think he would describe himself as such.
Yeah.
He characterizes the Israeli Supreme Court's jurisprudence as treating statutes as first drafts.
Yeah.
Treating statutes as first drafts, and I think that's an accurate description.
So as you were going through that list of all the good things, those are, of course, the kind of things that legislatures would think about when they're writing laws. And they're, of course, the kinds of things that executives would think about when the laws have left them a lot of discretion and they have to make their own kind of policy judgments within the limits of the statute how to go. In the hands of a judge who's not subject to elections, it does just seem like an open-ended assertion of power. But just really briefly, that brings me to the reform debates. Israel's had enormous debates in the last few years. So we in America have had a lot of debates about the courts too. But in Israel, you've had enormous debates that brought people out into the streets protesting against and for the proposed reforms. There are proposals to significantly reform the Israeli courts and bring much more power, for all the reasons we've discussed here, back into the elected, democratic, accountable parts of Israeli government. And of course, there are critics who worry that shift in power will itself unleash the kind of incentives that we worry about with judges, that there will be enormous discretion, not enough accountability. Of course, the political branches are more accountable, but they do worry that a parliamentary government without any kind of external check and balance would be able to move quickly and make enormous changes to society if it wanted to. So you have the pro-judicial reform side, there's the anti-judicial reform side, and there are some in and around the debates who might say, not yes or no, but not right now. I'm not going to ask you to sort of unpack all of the debates, but those debates happened a few years ago, or the protests happened. Could you give the audience a sense of maybe where the debate stands now, just practically speaking? Do you think that they will reemerge when geopolitical circumstances calm down a little bit? I mean, where is Israel sort of in the trajectory of those debates?
Sure. So I'll say a few quick things about the 2023 reform proposals, and you're right in the sense that I don't think really a post-mortem or an autopsy of those reforms is that justified or necessary. One thing that I really try and convey in the book is that even evaluating these reforms is almost impossible if you don't understand what preceded them and what the court has done over the past 40 years. So understanding what the reforms, whether they're justified or not, whether they're excessive or maybe even insufficient, right? Whether they're extreme or benign, all of this is a question which can only be evaluated on the basis of what has the court done over the past 40 years? What is the current status which the government was trying to fix? And without getting too much into the weeds over there, what I do want to, a point that I want to make is that I think, first of all, by any objective criteria, if you look at what the court has done and you look at what these reforms were trying to do, by any measure, the proposed reforms of 2023 were relatively benign. They were relatively, and when I say relatively, I mean relatively to other Western democracies, relative to what the court had done over the past 40 years. They were a almost minimal version of rolling back some of what the court had done, and I think I make a strong argument for that. I should say that the reforms serve as the backdrop for the book, but are not covered at length, and they're not a major component of the discussion in the book. What I will say is that, I think one of the people that said this best is Professor Alan Dershowitz, who I'm sure you might be familiar with, a major constitutional scholar and a criminal law expert in the United States. Professor Dershowitz is extremely supportive of the Israeli Supreme Court, personal friend of Justice Aaron Barak and other justices on that court, and he opposed the reforms. However, he himself was the first to say that there was nothing remotely anti-democratic about these reforms, and that the argument of essentially the protesting camp that these reforms were receding Israeli democracy or were undermining Israeli democracy, those arguments were ludicrous and preposterous. And this is Alan Dershowitz, who opposed the reforms, was saying this. He was saying, if the reforms were to pass verbatim as they had been originally proposed, it would have made Israel more democratic, would have given more power to Israel's elected and accountable representatives, and would have brought Israel closer and more in line with other Western democracies, like Canada, Australia, the United States, et cetera.
Yeah, that part reminds me a lot of debates recently in America, right? The Supreme Court famously or infamously overturned Roe v. Wade, said we're returning this issue to the states to make state-by-state policy. And a lot of the criticism of the Supreme Court was this is a horrible blow against democracy. When whether you're for Roe v. Wade or against it, one thing that's pretty clear is taking it from the Supreme Court and returning it to the states would be pro-democracy. It might not be a good thing. I thought it was a good thing, but it's definitely not anti-democratic. Okay, another irony I noticed around the Israeli reform debates here in America was there were a lot of Americans who were taking up the side against reforming the Israeli courts. And it seemed to me a lot of those same Americans were at the exact same moment a few years ago applauding the possibility of significantly reforming the U.S. Supreme Court, right? Packing it with additional justices, setting term limits on justices. And those debates, I think, are still happening somewhat in the background. They may reemerge again in a few years.
Ethics rules.
It's interesting that a lot of the same folks who were anti-reforming the Israeli court are very much in favor of reforming the U.S. Supreme Court. And it's interesting to think through what do those two things have in common and what do they have different. But one more thing. A few years ago, I was lucky to teach in Israel for a couple of weeks. I was invited to come over for a program of the Tikva Fund and teach young Israelis who had completed their military service about the American separation of powers and the relationship between the courts and the executive branch. And that was greatly ironic for me because here in America, I was in the middle of years of sort of joining the arguments for reforming judicial review of agencies, making judicial review less deferential to the executive branch. In a way, courts asserting themselves more against executive and administrative overreach. Now, of course, in the US, it's very different because we do have doctrines of standing and a more formal separation of powers. We have a constitution. We have an Administrative Procedure Act that explicitly allocates power. But it was, I have to admit, a little strange to be in Jerusalem looking through the other end of the telescope and talking with young Israeli students about the dangers of too much judicial micromanagement of execution. And so I guess that's maybe my last question before we open it up is, what advice would you give Americans who are interested in the debates around American legal reform? What advice would you give them based on your experience of seeing the Israeli experiment play out?
Well, thank you for that. And I should say, I appreciate that observation, and I think that that's demonstrates how much the details matter and how much ultimately, yes, you kind of sort of ask these questions or think about these things within the framework of your own existing debates. But at the end of the day, you can't really have an informed opinion and can't really understand these issues unless you understand the details themselves and understand the critical differences between between Israel and the United States and what's happened in Israel, what's happened in the United States. And to that effect, one of the points that I try and make in the book is that you kind of need to put out of your mind all your existing preconceptions about judicial power and separation of powers and deference and executive government, checks and balances, counter-majoritarian mechanisms, etc. That's all well and good. When you read the book, the vast majority of things that the Israeli Supreme Court has done are things that no progressive judge in America would get behind. No activist judge in America would get behind. 90% of that stuff. Maybe in their heart of hearts, they'd be okay with it. But on principled grounds, almost any sort of Western educated person who strongly believes in democracy and popular self-government, even in separation of powers and accountable government, could not, and of course in a principled view of the rule of law and of judging, could never get behind most of the things that the Israeli Supreme Court have done. Yeah. And if the Israeli Supreme Court were writing these things in English, they would be the laughingstock of the Western world. I think this is important because when you read this in the book, and there's a language barrier, et cetera, so many other things which sort of don't allow for this sort of understanding of what happens in Israel. But I think that's an important observation. I'll finish by answering your question properly, which I could go into this in quite detail, but I'll just say this in a very sort of simple way. I don't know if this is a lesson for the United States, but I think this is maybe a lesson or a question more broadly to be put to the Western world and among them the United States. And the sort of basic question is, and I'll take a minute to say this, was Hamilton wrong in Federalist 78?
Oh, yeah. Right.
And what can Western countries do about the genuine dilemma of a rogue judge, of a rogue courts? And does the US constitutional system, do the Federalist Papers really properly understand and address this genuine danger? And there's a lot to say about this, but what I'll say briefly is I think there's a good argument to be made that the Founding Fathers, including Hamilton and Federalist 78, and perhaps sort of Western democratic theory more generally, have underestimated the extent and the potential scope and extent and depth of judicial power. Yeah. Sort of had a sort of missing understanding or simply didn't predict the way that systems and institutions would evolve. And at the same time, overestimated the efficacy of a lot of their sort of proposed restraints on judicial power, overestimated the utility and the efficacy of different restraints and constraints on judicial power. And that has brought us to a point in history. This was the case in the US, maybe slightly mollified by the current conservative majority in the Supreme Court, maybe. This is certainly the case in many other Western democracies in the world, where you have had a radical expansion of judicial power. And Judge Bork's book about coercing virtue was prescient in that sense. But there are many other books now, Juristocracy by Rand Herschel and a Global Expansion of Judicial Power and others, which deal with this exact issue. So you've had a radical expansion of judicial power throughout the Western world. Based on these doctrines which really remove the court from traditional notions of the rule of law and democracy, et cetera. Yeah. And at the same time, you have experience throughout the Western world which sort of demonstrates or proves that a lot of the mechanisms that we thought might be in place to limit judicial power are not effective and haven't really worked. And I think this is, really requires a broader conversation. But I think the Israeli case study, to a great extent, shows you or demonstrates what goes wrong or what the catastrophic results can be when a court completely abandons the law and democracy, when a court completely goes off the rails, when a court goes rogue, when a court adopts the idea of rogue justice in a really fundamental way.
Yeah, and the way you put it, I guess, reminds me, the American founder that looms largest over this book isn't Hamilton. It's the writer that Hamilton was responding to, he wrote under the pen name Brutus. It's probably Melanchthon Smith in New York, I guess, but Brutus wrote, and eventually spurring Hamilton to write Federal 78, Brutus wrote that the risk inside the proposed American judiciary was that they had life tenure and a power of judicial review. And Brutus goes on to say, they are independent, these judges are independent in the fullest sense of the term.
Independent of the legislature, independent of the law, right?
And of the people themselves.
And of the people.
They'll put their own, they'll replace the laws with their own sense of the spirit of the laws. They'll be independent of heaven itself, he says. Then he goes on to say, there's nothing under heaven that will limit these judges, and men in such a position will begin to feel independent of heaven itself. And that does sort of reflect so much of what you're saying in this book.
I just want to respond to that one point, which is so important, because echoing that exact idea that Brutus was making, and maybe Brutus was right in a way that Hamilton didn't appreciate, is that take Lord Jonathan Sumption, British UK Supreme Court Justice, and he recently wrote and spoke greatly about the expansion of judicial power in the West, et cetera. And he talks about the sort of modern version of judicial power in the West, which is a system of law-based decision-making that would entrench a broad range of liberal principles as the constitutional basis of the state. Democratic choice would be impotent to remove or limit them without the authority of courts of law. And he later calls this sort of a priestly cast of judges, et cetera, et cetera. And it's interesting to see how his description of the current state of affairs actually kind of echoes this prediction by Brutus, in the old Federalist paper debates.
Well, I'm sorry, I never miss a chance to cite the Federalist and Brutus, and now we've gone a little bit long, and so I'm sorry we didn't get to questions sooner. If you have a question, raise your hand, and the microphone, we do have questions. We'll start right in the back, and then we'll make our way forward.
How are you? Thank you very much. It was very good. Elisha Marmon, I'm at Georgetown Law. I just wanted to ask, one of the big issues is with the reform. I'm a little more optimistic than a lot of people I know. I've spoken to people in Israel working on this who are optimistic. Why wouldn't the court just strike down the reform laws as being violative of their sense of decency or whatever exactly it is and call it a day? Why not just strike down anything that happens limiting their power or changing how the court works?
Great question.
Do you suggest collecting a few questions, or should
let's go ahead. Let's start with this. We might get to that later.
So thank you, Elisha. The short version is the court has already started doing so, meaning the court has already struck down, one sort of not flagship, but one major piece of the sort of proposed reforms. What's incredible about that, among other things, is that as a technical legal matter, the Israeli public has no recourse. Meaning at this point in time, as a legal matter, according to the court's own jurisprudence, the Israeli public has no mechanism by which to get its way. Unlike, you can say in other systems you have the possibility of constitutional amendment, or you can over time appoint justices to the Supreme Courts who might view things differently and might change those rulings and those precedents, as happened to some extent in the U.S. So the real answer is, I don't know. And I think this is why we're sort of in uncharted territory. This is one reason why Professor Yonatan called it a total constitutional dystopia. Because we're now at the stage where no one quite knows. The court has certainly really removed the last vestige of anything that could rein it in. Because if the court can now intervene with any law at any level, which even seeks to constrain the court's own power, then there really doesn't seem to be any formal mechanism by which the court can change. I will say that there's another answer to that very briefly, which is at the end of my book, I propose a constitutional assembly for Israel. And I feel that I'm fairly certain that if there were a constitutional assembly that functioned like a constitutional assembly, which is a fairly familiar mechanism, this isn't reinventing the wheel, if Israel were to come together and do something like that, and it were to produce particular arrangements, or even a constitution, then it would be much more difficult for the court to resist that and to push back against that. But that's a large, demanding, grueling, long-term process. And there's a lot of things have to come together for that to succeed. And that is probably one of the most likely avenues to eventually rein the court back in.
That's great. Okay, and then right next to you, ma'am, back there. Stuart, right there in the middle. And then we'll be up here in front.
Hi, my name is Sarah Barrett. I'm a dean of students at the Tikva Fund. This conversation, as I'm understanding it, is an attempt to understand the Israeli judicial system really from the lens of the American constitutional or legal tradition. What do you think the appetite is in Israel to approach the judicial system from this tradition or from this perspective? The large majority of Israelis do not have a connection or ancestral affiliation with the United States. So what is the appetite in Israel for this?
Great question.
Yeah, I really appreciate that question for two important reasons. One is I think there's very little appetite, right, in Israel, meaning Israelis generally don't know a great deal about what happens abroad in other Western democracies, including the United States, and maybe don't care particularly. First of all, I should say that part of the point that I make in the book is that, what the court has done also flouted its own precedents and its own rules for years and years, meaning even when compared with the court's rulings and precedents for the first 40 years of the state, which were very much, soundly reasoned and justified, even those were flouted. So even comparing these two eras, that's sort of one part of it. I was once asked in an interview, right, do Israelis, and this is the backdrop of the reforms and the protest movement, do Israelis really prefer rule of judges over democracy? And my answer was, a great many Israelis don't know that there's a difference. And this is where I think this does come in, not necessarily about the US per se, certainly the US as the pioneer of constitutional democracy as we know it, the US as one of the foremost examples of functioning, long-standing constitutional democracy, but perhaps more generally, absolutely, the Western ideas of democracy and popular sovereignty and fundamental and individual rights and all these things. Israelis need to better understand how the West views democracy and what the conversation is about democracy in the West. And this is something which Israelis are generally completely insulated from. This is something that Israelis are virtually unaware of. And this is how you can get away, as an Israeli politician, you can get away with saying political involvement with judicial selection is the end of democracy. Or judges being limited in any way of exercising their discretion or their intervention is the end of democracy. Or politicians being able to appoint anyone they want to executive government within the constraints of the law is the end of democracy. And these are ludicrous ideas and arguments. And perhaps at that point, I also want to make the point, this is also an important part of this. So much of what the court has done over the past 40 years, was in the name of democracy writ large. Because of course they couldn't found it on Israeli law. They couldn't found it on Israeli statutory law. They couldn't found it on Israeli precedent, right? They couldn't base this on any sort of conception of what the law was in Israel. So the core of the argument for so many years, and by the way, including this most recent case for the unreasonableness case in 2024, when the court struck down the unreasonableness amendment, they said, this is offensive to Israel's core character as a democracy. And this is so, this violates Israel's democratic character so strongly on a principled level that it cannot stand. This was the court's argument. So throughout the years, the court's argument was, it was channeling and implementing the principles of democracy, generally speaking. And Aharon Barak's famous book, which he translated also to English, was The Judge in a Democracy. Aharon Barak is the sort of the justice who is the driving force behind judicial supremacy in Israel. And he wrote about the judge in a democracy, not the judge in Israel, not the judge in whatever. So I think it is extremely important and a really important element of countering judicial supremacy and countering what the Israeli Supreme Court has done is to look at other jurisdictions, whether it's the US or other Western countries. Because at the end of the day, there's only so far that Israelis can ignore that. And if you fix that ignorance, that particular gap in Israeli knowledge and understanding of Western countries, you will already be much closer. And I should say you already be much closer to fixing this problem. And I should say that the only other prescriptive suggestion that I make at the end of the book is increasing Israeli literacy and education around what democracy is and what it means.
I have to admit, when I went to Jerusalem to teach American separation of powers, I did feel a little awkward showing up, and I thought, what's my first line? Hi, I'm Adam from America. Let me tell you how we do it. That's not very exciting. Okay, we have 2 questions left in 3 minutes. We'll go with you, ma'am, and then you, sir. And I think that's all the time we're going to have. I'm sorry.
Hi, thank you. My name is Jan Bates. I wanted to ask you something related to the previous question, which is, has your book, or will it be published in Hebrew in Israel?
Yes. I appreciate that question. The answer is, I certainly hope so. And I would like to translate it to Hebrew. I'm just in the course of trying to think about how to do that. It's an expensive project, and I'll have to probably raise some funds to do that properly. If anyone here is interested in supporting such a project, you should feel free to approach me afterwards.
And everybody watching on the cameras.
Right, everyone watching on the
home,
cameras, that's you guys, yes, interested in supporting this project. I do it slightly ruefully, or with a tinge of regret, and I'll say, and it's not really regret, but I'll say why. This book was written for a non-Israeli audience. And that's true to some extent in its substance, right? There are certain things which I explain in the book which I really don't need to explain to an Israeli audience, et cetera, and that can be sort of played with. But really, for an Israeli audience, I would need to write a completely different book. Now, I'm not going to do that right now. I'm going to stick with this book, and we're going to translate it, and I think it will be extraordinarily useful to an Israeli audience. However, this book relies on your understanding as a person from a Western background, a Western educated person, who has grown up and sort of seeped in the Western tradition of democracy. And the book is replete with ideas and examples which you will intuitively understand are problematic. You will intuitively see that something is a violation of separation of powers, or something is a clear violation of principles of the rule of law, or democratic self-government, et cetera. And to an Israeli audience, that will be far less obvious. And I've had conversations with Israeli lawyers, educated in the top Israeli law schools, and this is part of the earlier conversation we were having, right, where Israeli lawyers and Israelis more generally are just taught the idea that democracy means oligarchical rule by judges. This is what they're taught, that the meaning of democracy is you have to have an unelected clique of ex-lawyers in robes who get to decide the final outcome of all questions of policy and priorities and values. And this is just what they're taught. So you have that ignorance that you need to gap. And I was going to say, I've had conversations with lawyers in Israel where I'll say, I'll ask, will you concede that a judge telling the prime minister who they can and cannot appoint as a cabinet member, right, on the basis of reasonableness, that means just on the pure basis of nothing, sort of metaphysical, right, a shamanic ideal sort of drawn from the ether. Is that a problem of separation of powers? Can you concede that there's a separation of powers problem here if judges are telling the prime minister who to appoint as cabinet member with no basis in law? And they'll say no. There's no problem with separation of powers here. So this is why ideally it would be a very different book in Hebrew. However, I think it'll be enormously effective and impactful in Hebrew as well. And I'm very much hoping that we translate it soon.
We're running up against time, so you, sir,
Yes.
get the last question real quick.
And I'll be quick in my answer to let everybody go.
I thought maybe Daniel would have a question over here.
I'm Gerald Chandler. Would you make a comment? It seems to me that the Israeli judicial supremacy is very much like the Iranian supremacy of their higher council. So could you comment on that?
I will just say that you're not the first to say so, and that Professor Stephen Calabrese, one of the world's preeminent comparative constitutional scholars, has made that precise observation. And I should say I believe that's the quote at the beginning of my chapter on judicial supremacy, where he says that the Israeli Supreme Court is a judicial oligarchy much like the Iranian Guardian Council, which is not something you would want to emulate, which I think is an almost exact quote. And David Wormser also made who's a sort of actually kind of a foreign policy and national security expert, who's also kind of made a similar observation. Thankfully, Israel is not a theocracy, a despotic theocracy like Iran. But I appreciate that observation because so often in Israel, the sort of supremacist camp or some in the left-wing camp will say, oh, Israel is on the cusp of becoming a theocracy like Iran, or Israel, you have this phrase, Iran zekan. Iran is here in Hebrew. As if, everything the government does is just brings us a step closer to creepingly becoming like Iran. And the truth is that if Israel resembles Iran in any way, it's in the context of judicial supremacy. And it's in the context of unaccountable, insulated, undemocratic power accrued by this institution, which is insulated from the public. So I appreciate that observation, and I think it's true.
So your books attracted a lot of great reviews. There was one in Commentary Magazine by Judge Roy Altman. Ilya Shapiro of the Manhattan Institute reviewed it. But I highly encourage folks in this room to read the review by my colleague Daniel Sammet was it at Law and Liberty? At Law and Liberty. So look up that review or look up Daniel Sammet's scholar page here at AEI, and the review will be reposted there. But of course, also read the book. We have free copies for you to take and to get signed by the author. And speaking of the author, please join me in thanking Yonatan Green. Thank you. That was fun.